Right, Year 10 Legal Studies. We finished Unit 1, which is all about comparing values and systems in the legal system, and we looked at, in particular, Australia, Indonesia, Japan and India. Today we're going to start Unit 2, which is the role of the High Court in Australia. I think if you have a look at our little mud map of where we've been talking about, we've done a lot in the past about the legislative and how laws are made. We do a little bit on the executive and how the Prime Minister and the Cabinet enforce or enact the laws. So the High Court fits in this middle section, and that's to interpret or analyse the law. At the time of Federation in 1901, the Australian Constitution came into effect. Section 71 of the Constitution outlined the role of the High Court. So as you remember, the Constitution is broken up into chapters, and each of the chapters align with each of those separation of powers, so the legislative, the executive, and the judiciary. Section 71 falls in the chapter on the judiciary, and it set out the rules on how the High Court is supposed to run and gives it its boundaries as to how much scope and power and jurisdiction it has. So Section 71 says the judicial power of the Commonwealth shall be vested in the Federal Supreme Court to be called the High Court of Australia, and in such other federal courts as the Parliament creates, and in such other courts as it invests with federal jurisdiction. The High Court shall consist of a Chief Justice and so many other justices, no less than 2, as the Parliament prescribes. So it gives the Parliament some scope there to legislate, I suppose, on the functions and the ins and outs of the High Court. But essentially, Section 71 can't be changed without a referendum that we will have a High Court. The rest of that chapter then goes on to talk about the powers of the High Court. But I just want to show you this diagram first, which talks about the hierarchy of the court system and how it sort of fits out. So the High Court is the blanket one. It's the big one that fits at the top, the umbrella. Pursuant to it, there's a number of federal courts that have federal jurisdiction in accordance with the Constitution. So you remember that the Constitution also splits it into a division of powers. So this here is split into federal and state levels. So you have a federal legislative and a state legislative, a federal judicial and a state judicial. So we're talking about the federal judicial here of the High Court. And each of the states have their own Supreme Court. So in Queensland, we go Magistrate District Supreme Court. From there, they can apply to the Court of Appeal, which is in the federal jurisdiction. And then from there, file up to the High Court. So you go Magistrate District Supreme, which is the Queensland State Courts. From there, you'll go to one of these others, but probably the Court of Appeal, and then from there, High Court. These other ones are specific. So same as what we've done here with splitting it between Magistrate, District and Supreme, and the little matters go to Magistrates Court, more serious to District and most serious to Supreme. There's a split in the federal courts, Native Title Tribunal, Administrative Appeals Court, Federal Magistrates Court, Family Court, Industrial Court, and then the Federal Court. So these are for less serious ones, or specifically, like this is divorce and childcare maintenance and that sort of stuff. These are native title claims, so for Aboriginal and Torres Strait Islander peoples who want to show a connection to their land and get land rights back, they can go through there. And then you've also got a Federal Magistrates Court, which deals with less serious offences. So the High Court is the big one, and the big role that the High Court plays is to make determinations on the validity of the elections for representatives and interpret the Constitution. This is a massive key role, this one here. High Court Australia interprets the Constitution, because the Constitution is what legislates and regulates the Parliament. So when the government is elected, they're the highest power in the land, but the government has to still stick within the boundaries of what the Constitution says. And if they start to step outside that, then the people of Australia or whoever can go to the High Court and say, hey, we don't think that they're following the rules. Can you check on this for us? Or the Parliament might even say, hey, look, we're not sure how this works. This is what the Constitution says. This is what we want to do. Do you think that matches up? So the High Court has the power to basically rein the Parliament in if they're not doing what they're supposed to be doing under the Constitution. And that is key to that separation of powers. Because if you get a Prime Minister or a government who wants to do whatever they feel like and doesn't want to follow the Constitution anymore, that's where the High Court can step in and protect the rights of the Australian people pursuant to the Constitution. It's also referred to as the court of last resort. So if you get a dodgy decision in the magistrates court and it follows all the way through, the High Court and the 7 High Court justices sitting on the full bench would be able to say yes or no and give a determination on that, whatever case it might be, whether it's a criminal case or a case about money, so a civil case. The High Court is the last court of the last resort. So if you get to the High Court and you get a decision there, you're on your own. Now, there's some scope there. Obviously, we talk about international law at some point in the future because there's an International Court of Justice, and if you're not happy with the answer that the High Court gives you, you can go to the International Court of Justice. But the International Court under the United Nations does not have any jurisdiction in Australia unless the government wants to follow that, because obviously Australia is its own sovereign nation. So the composition of the High Court, you can see here, Justices of the High Court standing left to right, Justice Hayden, Crennan, Hayne, Keffel, French and Bell, looking very formal there in their garb. So that's the 2014 crew. It's changed a little bit since then. There are 7 justices, a Chief Justice and 6 others. The justices are appointed by the Governor-General on the advice of the Prime Minister, so that's another role that the Governor-General plays. Remember that the Governor-General is the representative of the Queen in our system. The number of judges sitting on a case will reflect its importance. If you've got a changing of the Constitution or something really serious like that, or the government is accused of stepping outside their scope, then you'll have a full court. But if it's just a routine offence or an application, you might only have 2 or 3 or 5 judges sit there. Justices cannot be removed except by the Governor-General, and but are required to retire at the age of 70. So, to summarise, functions of the High Court include interpreting and applying the law of Australia, hearing appeals from federal, state and territory courts, deciding on challenges to the validity of the Australian constitutional laws, and the High Court justices also need to take into consideration Australia's legal obligations under international treaties and conventions. So we touched a little bit on the United Nations there before, and international law. We do that at a later date in much more depth, but essentially the power to apply international law into Australian law resides with the federal government, and when they sign a treaty or sign a piece of international legislation that the rest of the world has decided upon, that then filters down and becomes part of our laws, and that's where the High Court can put those in place. So hearing appeals from the federal, state and territory courts, the High Court is the final court of appeal for all legal actions in Australia. As the High Court of Australia is the highest court, appeals can be made to that High Court from lower courts, but only when permission is granted. You can't just go there because you feel like and you're not happy with the answer. You've got to have grounds. You've got to have some sort of mistake or new evidence, or something has to come in to allow it to go higher. Generally, appeals to the High Court only occur when important points of law need to be interpreted. A case appealed from a state court will result in a decision made by the High Court of Australia that is binding across all state courts. Remember, we've talked about precedent. When the High Court sets down precedent, every other court in the land has to follow it because it's binding, because the High Court is the highest court in the country. So the rest of them fall within that hierarchy and would fall underneath that decision. All citizens have the right to appeal to a High Court if they feel they've been unfairly treated. The High Court of Australia is the highest court of appeal, and all decisions made there are final. So that's a key point from that slide. So it interprets Australia's constitution. The justices consider Australia's legal obligations under international treaties, and it interprets and applies Australian law. I just want to go back to this one here, deciding and challenges the validity of Australian constitutional laws. The biggest one that we'll have a look at is the Tasmanian Dam case. Now, in that case, we might have spoken about it before. In that case, the Tasmanian government wanted to put a dam in Tasmania. And where they wanted to put this dam, so a dam is obviously where you put a big wall up and you stop a river, and the river hits the wall and starts to fill up. So this area that was going to fill up with water, there was a special type of frog that was there. And this frog was the only kind of its only place that this type of frog was found. So it was a national treasure, basically, because it was an extinct animal. And the putting of this dam in place was going to destroy the habitat that this frog lived. So basically exterminating this frog, it was going to become extinct. So the people in Tasmania who disagreed with this decision of the Tasmanian government went to the federal government and said, hey, we're not happy about this, can you do something about it? So we had an issue there where the federal government agreed and said under international law, because they'd recently signed the Convention on the Protection of World Heritage Sites and basically protection of the environment. So the federal government agreed and didn't agree with. At the time, the federal government was a Liberal government, and the state government in Tasmania was actually held by the Labor Party. So you can see there's going to be some politics played out as well. And so the federal government said, we disagree with this dam, we're going to do what we can to stop it. You can't put it in there. And the Tasmania government said, you can't tell us what to do, mind your own business. So it went all the way to the High Court, and that's where the High Court got the Constitution out and said, righto, who has jurisdiction here, or who has the authority to make the decision? And the power to make laws based on international treaties resides with the federal government. Because they had signed the protection of World Heritage listed sites under that international legal convention, then they had jurisdiction. And the Constitution says that where the federal government has jurisdiction and there is any sort of contradiction or contest over it, then they reign supreme, and that what they says goes. So in this case, the Constitution said, and the High Court interpreted it to mean that the federal government was in the right and had the jurisdiction, so the dam didn't go ahead. So you can see how even when the Constitution is very clearly set out and politicians are, and have legal advice and are lawyers themselves, most of them, that it can be a bit confrontational at times, or there can be conjecture over what the Constitution says and what it means. And this is where the High Court plays a role and can adjudicate on all of those sorts of things. So a very important function performed by the High Court. As I said, it's key and integral to this whole separation of powers. It is the check and balance on what the legislative is trying to do. So a very important role that the High Court plays. So if you can take some notes on that and also read chapter. If you can start working through the chapter 3 questions that I've assigned you from Jacaranda, and we will continue those and do some worksheets next week to round off our unit on the High Court. Thank you.